Hello, this is Matt on the Moon Lambeau channel. Today, the SEC filed a new document in the SEC versus Ripple case, which objects to XRP holders being heard in this case, despite the fact that the SEC claims to have brought this suit against Ripple on behalf of XRP holders. What? Well, yeah, I know, it makes no damn sense. So, the SEC here, continuing along with their Chewbacca defense. I admit, the Chewbacca defense, very hard to beat, but I think that Ripple's team of lawyers can beat the Chewbacca defense. So I'm optimistic, cautiously optimistic here. And so Attorney John Deaton, I'm sure at this point the vast majority of you listening are well versed with who Attorney John Deaton is. He's a pro-XRP attorney who is seeking to do a number of things. Intervene in the SEC versus Ripple case to make the position of XRP holders known, because right now it's honestly not being sufficiently covered. Nothing against Ripple, I don't mean that. But on top of that, he's also seeking to have a class action lawsuit against the SEC for the damages that they've caused, because they've just went in like a wrecking ball and just caused literally billions in dollars of financial devastation to XRP holders. So that's how the SEC is rolling. So SEC attorney Jorge Tenrero, he submitted this document to the Honorable Judge Annalisa Torres, which you'd think would be a mistake. I'm pretty sure he meant to file this garbage directly into the trash, but it did go to the judge instead, so now we got to talk about it. Now, I do want to be clear that I don't have a legal or financial background of any kind. I am not offering financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos as a very fun hobby on the topics of Ripple and XRP and crypto stuff in general, but that is all that it is. And so here's a tweet from John Deaton just about an hour and a half ago. As I record this, what is it, 8:47 p.m. on Friday, the 26th. And John Deaton, that's, by the way, I'm in the Midwest, that's Central Standard Time. John Deaton wrote the following. The SEC objects to XRP holders' voices being heard in a case it allegedly brought on our behalf. And then he tagged Ripple and Brad Garlinghouse and Chris Larson and wrote, take no position at this time, but agree we should be permitted to proceed with our motion. And so I do want to take a chance or an opportunity here to plug not just John Deaton. If you haven't followed him at this point, seriously, you got to follow him on Twitter. He's at John John, middle initial the letter E, last name Deaton, Deaton, and then the number 1. And also he started Crypto Law US. Here's the official Twitter handle, at Crypto Law US. The website is crypto-law.us. Check him out. It's got all sorts of legal filings having to do with the Ripple SEC case and other stuff just related to crypto in general. And so I wanted to plug them because I like to give credit where it's due, frankly. Anybody that's contributing to the XRP community in some sort of meaningful way, I always want to make sure to give credit where it's due. And both fantastic follows. And so I tell you what, I'm gonna cover some of the specifics of this document. I did read through it one time quickly, and there are a few spots I know I want to highlight, but if I go through the whole thing, it would be too long of a video. And also, I'm going to wait and see, even though we got some initial thoughts from a couple attorneys in this video I'm going to share with you, I'm going to wait to get, since I don't have some sort of professional legal opinion or background, I'm going to wait until I get some additional thoughts from attorneys before I share more in a future video on this. And I'll be happy to share my personal opinion, but sometimes it's from a legal perspective, like actually most of the time, it's hard to make heads or tails of, from a legal perspective, the way things might go or what might be relevant. From a logical perspective, yeah, I can sit here and share my opinion, which I enjoy talking about this stuff, certainly. But as far as what's a good legal defense, what isn't, that's where I need the insight from the attorneys that are in the XRP community that regularly speak out. So first, I'm going to go ahead and jump into this. Yeah, take a look at this. So somebody asked John Deaton, what does this document mean? What will be our response? And John responded, we wait to see if the judge will allow us to file the formal motion. I sure hope so, because what the SEC is claiming is total BS. And I'm having to censor that. I need to heart that one. That's good. I like the fire. And so we are still waiting here from the judge. So John Deaton filed the motion to intervene in the SEC versus Ripple case. Hopefully that goes through. And so this is just the SEC trying to say, no, Judge, we don't want them to be in that case because we're asshats. That's basically what it is. Yeah, end of video, right? I don't need to say any more than that, do I? And so then there was this very short thread from John Deaton I wanted to highlight. It's exactly on this. And so he wrote, I haven't spoken to Ripple or its lawyers about what I've been trying to do, although some of you have tweeted that I should. But Ripple's lawyers sent a message in their response. They hinted that maybe there is a role for us, even if it's not intervention. And so here's a quote. But defendants, and this is from Ripple, but defendants take no position at this time as to whether intervention or some other, more limited, participatory rights, such as elevated amicus status, are appropriate. So right there, and that was a direct quote from Ripple. So Ripple cites a couple cases where the court offered elevated amicus status after denying a motion to intervene. And so this would permit XRP holders to, quote, aid the court and offer insights by filing briefs and presenting arguments that respond to the issues presented by the parties. And then you're absent by stating, if we don't get to intervene, then hopefully the judge will allow us to participate in this manner. I certainly hope so, because right now, I mean, think about this. Think about the millions of people that have purchased XRP over the course of the last 8 years, and not having a say in a court case that's going to, in a very fundamental and powerful way, impact the long-term viability of XRP as a cryptocurrency. And just think about that. And so this is the idea that we XRP holders shouldn't have some sort of voice is that perspective is disappointing to me, to say the least. Maybe that's a bit of a euphemism. And then attorney Jesse Hines jumped in on this. So he saw what Crypto Law US shared. He saw that John Deaton retweeted that from Crypto Law US. And so this is what attorney Jesse Hines had to say on this topic. The best part about Ripple's response was a very simple but very important attempt to get the SEC to clarify one thing. And here's a quote. If the SEC confirms that it will seek to establish only that the manner in which defendants marketed and sold XRP determines whether their sales of XRP were an investment contract, and that it will not seek to establish that secondary market XRP transactions violate the Securities Act or the Securities Exchange Act, interveners' need for participation in this matter may be limited. And so they're talking about whether or not entities other than Ripple, if that represents an investment contract, whether or not it does, that would be a major factor in whether or not interveners should be able to come into play. And so Jesse Hines continues. If, however, the SEC continues, and this is the quote still, if, however, the SEC continues to equivocate and refuses to clearly state its position on these issues, interveners' interests in the outcome of this litigation could be different. Exactly. So if it's the case that anybody that's sold XRP, if XRP is still going to be an investment contract just in a general sense, then it's more clear, if I'm interpreting this correctly, that he's saying, there's more of a reason for interveners, XRP holders as interveners to participate within the court. And so here's what Jesse Hines said to wrap up after that quote there. So, if this goes to oral argument, my hope is the judge asks the SEC this question directly. Are you alleging that any of the XRP sold on secondary markets are investment contracts? The answer to this will decide whether you start seeing relisting, in my opinion. So, we're talking about XRP getting relisted on exchange. So, relevant comment. And so in response to that, John Deaton saw what Jesse Hines wrote and said, if we are provided an oral argument, I intend to force the SEC to address it. And so now into the document here, and it's par for the course, I know, but just reading through this, it's just offensive. It's like, in reading through this, it's like, I want to know if Jorge Tenreiro thinks that anybody reading this is functionally stupid. Do we have some sort of mental handicap and we're just going to read this and be like, oh, yeah, that makes sense. Yeah, this has got to be true. This really burns my biscuits. And so this is what was filed today. And again, I'm just going to go through a few select parts. I'm sure there will be lots more to talk about on this topic in the next day or two or three or whatever. But here's how SEC attorney Jorge Tenreiro begins this. Dear Judge Torres, Plaintiffs' Securities and Exchange Commission, SEC for short, respectfully responds to the March 19 letter, apparently on behalf of XRP holders, which are the movements. Let me just pause right there. Can't even make it out of the damn first sentence. What do you mean, apparently filed on behalf? It's on behalf of XRP holders? What is a... Oh, so think about this. This individual is so misleading, so disingenuous that he won't even state what is flatly obvious, that this was filed on behalf of XRP holders. Why would anyone dispute that? And so he throws in the word apparently as if, well, we're not really sure if this is for the XRP holders, but apparently it is. I don't know, like, apparently it's the XRP holders. I don't feel a proof of it. That's exactly what's going down here. That's what he wants you to think. Like, he thinks you have a cashew-sized brain and don't know what the hell John Deaton's filing was on behalf, like who it was on behalf of. Grinds my gears. All right, continuing on. Setting forth grounds on which movements seek to move to intervene under, and then they cite some sort of legal code or provision. Movements do not explain what claims they would assert against whom in this action if the court were to permit them to intervene. But Congress has barred by statute the consolidation or coordination of claims without the SEC's consent, and sovereign immunity bars movements' claims against the SEC. That alone precludes movements' proposed intervention. So as far as the sovereign immunity, I think that's the whole thing where the government's basically protecting itself from being attacked in any sort of legal way from anyone. There's like, I don't know what the legal purpose of this is, but even Attorney Jeremy Hogan brought this up, where he's like, you know, if you want to sue the federal government, you have to give them 6 months notice before you can actually do that. And even he says, like, yeah, I don't know why, but that's it. And it's very difficult to successfully sue the federal government. And so I believe that's what he's referencing there in terms of sovereign immunity. I think that's the term that I heard associated with that. But, you know, as far as not asserting, you know, there was something else that he wrote, and I can't remember where I saw it in the document, but it may have been right down here. He's talking about vagueness or something like that. It may have been right here. Let me check. I think this is it. Under Section 2, motion to intervene. Movements now seek to intervene in this action under, and then they name some sort of legal code or whatever, though they do not say what cause of action they wish to assert against which party. Instead, they vaguely state that they wish to ensure that adjudication of this case considers the full array of vested property interests at stake, and to make sure those interests and related rights are fully vigorously defended. So let me pull up this, because this is a March 19th letter from John Deaton to Judge Torres. Now, again, the claim that the SEC attorney Jorge Tenrero made was that John Deaton's letter here and the filing, he's been very vague. And so here's a 5-page letter of vagueness. 5 pages of vagueness. You can't really figure out the reason he's even filing a thing, right? There's only 5 pages. There should have been a minimum of 11 billion pages to be sure that John Deaton was not being vague, right? This is clearly not enough documentation here. Well, do you see what they're doing? Like, how could anyone take this at face value? It's just the level of disingenuousness is kind of gross here at this point. John has made, and I'm not going to go through this letter in this video because I've already thoroughly gone through this, and he makes a ton of awesome points, and he makes it pretty clear what we want to do. But here there's this claim in this new filing, which went to the judge when it should have been filed in the trash, claiming that it's just too vague. We don't even know what's the purpose, this or that. Should they even be here? And then it states, movement's primary motivation appears to be to reinstate speculative trading of XRP on digital asset platforms so the movement may sell XRP to other investors at a profit. Movements point to the economic damages suffered by movements now incorrectly assert that the SEC's motion to dismiss their mandamus petition, quote, made clear that this court provides the exclusive forum to hear all matters related to its actions against Ripple and XRP, and thereby suggest that the SEC invited his intervention. Yeah, actually, let me just shift to this, because again, I don't want to go through the whole thing. Let me stick on the point as far as not just vagueness, but this idea of reinstating XRP, because in the next section, I think it was the next section, where did I see this? They said something that also just, like, offended my intelligence, basically. I believe it was right here. Let me read this. I'm pretty sure this is the spot. I apologize if not, but I think this is it. So here you go. Section 21G of the Securities Exchange Act of 1934 and sovereign immunity bar whatever claims movements seek to assert by intervening. This may have been it. Okay, so to the extent movements seek relief against the SEC for alleging the SEC knowingly and intentionally caused multi-billion-dollar losses to innocent holders of XRP, letter 1 noting economic damages suffered by XRP holders, and then he's citing Section 21G again of Securities Exchange Act of 1934, bars such claims for relief providing in relevant parts. So this must be where I guess he's citing 21G here. So I think this was the part I want to cover there. No action for equitable relief instituted by the Commission pursuant to the securities law shall be consolidated or coordinated with other actions not brought by the Commission, even though such other actions may involve common questions of fact, unless such consolidation is consented to by the Commission. Okay, so it's actually a different part, but I did want to highlight this in the video too. The way that I took that, if I interpreted correctly, it's basically, you're claiming that we, the SEC, an army of asshats, you're claiming that we asshats caused $1 billion damages to XRP holders, multi-billion-dollar damages here. And basically, it looks to me like they're just, again, it's just another instance of them pawning the responsibility off to exchanges here. And maybe it was... There was another spot. I know there was a spot in here, and if I can't find it, I'll just tell you what I know it was about. But it had to do with... let me go back up here. It had to do with... I lost my spot. I apologize, guys. You know what? This is somewhat off topic. Here's what I did. So with all these legal documents and making these videos, it's tough to track the stuff that I want to highlight. And so, like, I own a ton of printers at my office. I'm a business owner, but I don't have one for home. I finally just bought a LaserJet printer, and I'm having it shipped here. And so what I'm going to do is highlight stuff so this doesn't happen in the future. So I do apologize, but I don't normally have to have documents printed up and highlight stuff, and I never need to print anything at home until this happens. So, but finally I'm like, okay, this has happened enough to where I just need to, like, prep this. But there are like 3 spots where I thought I'd be able to recall off the top of my head here, but now on the spot I'm choking, I guess. So I'm sorry, guys. But I may just have to come back for this. Investment contracts. Maybe that would be best here. Yeah, I don't see it. I'm sorry here. Yeah, movement's primary motivation appears to be reinstate speculative trading. It was on that topic. Yeah, I remember what they said though. So like the claim was, okay, so on this point, movement's primary motivation appears to be to reinstate speculative trading of XRP on digital asset platforms so that movement may sell XRP to other investors at a profit. And so they made that point somewhere else in this document also, and they said that the fact that this is the case, this is what we want, this just proves effectively that that XRP, if it leads to their argument, which is basically that XRP is a security. That's effectively the argument that they were making, but that's just not true. Like, we want XRP to be traded on platforms because you can't get new people into the ecosystem, even for purposes outside of trading and speculating, if they don't have access to XRP. So without XRP being traded on exchanges, yes, XRP can be transacted without a central authority on the XRP ledger, but then it's just those people that are already in the ecosystem. So what you're doing is you're cutting off everybody else on the planet that doesn't have access to it. Well, certainly in the United States that's the case, but imagine it were not listed on any exchange on the planet. Well, you know, it's not just about speculating. Yeah, people are going to speculate on anything. They'll speculate on gold. They'll speculate, you know, precious metals, and they'll speculate on stocks, all that stuff. Of course that's happening. But the idea that this is purely for speculating and that makes their case, that's the point that I wanted to bring up. I wish I could have find the sentence where they pointed it out exactly in that fashion here. But no, that's not the only reason. You know, developers won't build on top of the platform if people can't get access to XRP itself. Like, it's just not going to happen. XRP is functionally useful, and it's a core part of the XRP ledger itself. And so that's the point I ultimately wanted to make. So I apologize for kind of flailing about here while I was searching for this, and thank you for putting up with me if you made it this far. But hopefully I can reduce this type of mishap occurring in future videos. Not that it happens that frequently, it really doesn't over the course of my 2+ year history, but now that I got a printer on the way and I got some highlighters, I'll highlight the spots I want to talk about and go from there. So there we are. But again, like I said, I never had a need for that prior to this SEC versus Ripple lawsuit, and now it's become necessary. So I feel like I'm traveling back in time by purchasing a printer and printing stuff on paper, but it'll be easier that way. All right, well, let me know what you think in the comments below, but I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.